prosecutor's job is not to convict people or to put them in jail. It's to do justice.
There's an old adage that the last place that you should seek justice is in the halls of justice.
The federal criminal justice system carefully has evolved with checks and balances, and it works.
Prosecutors exercise a tremendous amount of power, and they're given a tremendous amount of authority. And with that, they ought to exercise it responsibly, and there needs to be some oversight for that.
This is not a new debate. This is a debate that we've been having for as long as the criminal justice system has existed.
So a prosecutor is a public official who is assigned the responsibility to prosecute individuals who have been accused of committing criminal offenses.
They have the responsibility to ensure that the laws passed by Congress and signed by the president are executed.
I see the prosecutor as wielding the most enormous power of anybody, any government official when you think about it. And I'm talking about exercising legitimate power that can deprive a person of his liberty, destroy a person's reputation, and actually take away a person's life in those jurisdictions that have capital punishment.
Unlike a civil lawyer who is hired by a client who is staying within the bounds of ethical rules to try to win their case, a prosecutor's role is not to win at all costs. It is to seek an indictment and charges against the guilty, and also to investigate and try to exonerate those who are not guilty.
My view is that prosecutors are performing a public service, and we have a system in which there is adversarial litigation in criminal litigation. So you have prosecutors on the one side, you have defense counsel on the other side, and we practice every day against some very, very talented and dedicated defense counsel. And prosecutors are necessary for that system to work.
I don't know that it's an inherent flaw to have an adversarial system of justice in which prosecutors advocate for one side. I think what's extremely unwise and misguided is to suppose that they can in fact wear these two hats. An advocate for the government on the one hand, and an independent officer of the court charged with doing justice on the other.
Defense lawyer is supposed to zealously defend their client. I'm supposed to sacrifice myself over the client. That is not the mantra, the ideology, the ethos of a prosecutor. Prosecutor's got one duty and one duty only: seek justice. Unfortunately, that isn't what happens in America.
To do justice, to balance your obligation to convict guilty people, but also serve the cause of justice, you need a huge amount of discretion in it to be able to make these very, very difficult choices. Choices that depend on the evidence, choices that depend on the charges, choices that depend on the nature of the offender.
Prosecutorial discretion is one of the most critical functions a prosecutor has. It's a gatekeeping process by which we look at cases that come in. We can't, either in a federal system or in a state system, you can't prosecute every crime that's committed, nor should you.
Justice Jackson, when he was the Attorney General of the United States, gave a speech on April 1st of 1940 called the Federal Prosecutor. In that speech, he addressed prosecutorial discretion, and he explained that the prosecutor should seek to bring charges in those cases where the defendant's conduct is the most egregious, where the public harm is the greatest, and where the proof is the strongest. And that's essentially what prosecutors do.
I do think that prosecutors need to have a certain amount of discretion in how they go about their job and the decisions that they make. But I think we've allowed the process to become so lopsided, where it really is basically run by prosecutors.
Prosecutors are certainly powerful and important players in the criminal justice system, but not in a way that is improper. The idea that they're running the show neglects a lot of other players in the criminal justice system.
Prosecutors generally in our system of government have a fair amount of discretion to decide what charges are appropriate, decide who's appropriate to charge, decide how to resolve a case, whether through a plea bargain or going to trial. after the Civil War, there was a significant rise in crime, and with that, a need to resolve cases in an expeditious, efficient way to prevent the system from being clogged. And that's how plea bargaining came into being. The essential concept of a plea bargain is that the person who pleads guilty admits guilt to some offenses and then gets some sort of benefit for having done that.
There were something like 11 million arrests last year. That's a lot of people to process through the system. And there's fairly wide agreement among experts that if every criminal defendant exercised their constitutional right to a jury trial, the whole system would just grind to a halt because we just don't have the resources, or more accurately, we are not prepared to commit the resources to ensure that every criminal defendant gets the jury trial that they are constitutionally entitled to.
When they don't contest their guilt, it would be a huge waste of our resources to bring citizens in from the community to sit through a trial where there's no contest, where everybody agrees that the person's guilty. It's more important that we focus those limited resources on the individuals who contest their guilt and give them full due process.
I think there are more cases than ever that are now ending in a plea bargain. I think it's now about 97% of cases end in plea bargain.
You have to do nothing more than take a look at the number of people that go to trial in the federal system. There are federal judges who've never tried a criminal case. There are federal judges who have retired from the bench who've never heard or had to their clerk read the words "not guilty" in their courtroom during their entire federal career, which should give you great pause if you're a citizen in the United States of America.
From about 1960 to 1991, violent crime spiraled upward. It more than tripled. During the mid to late 80s, Congress responded and they implemented mandatory minimums. And federal prosecutors working with state and local partners began to go into the communities and take out the worst, most violent, significant drug traffickers and other violent felons. And they took those folks and they put them in federal prison. And it worked well because beginning in about 1991 and continuing to about 2014, the violent crime rate was more than cut in half.
If somebody is convicted of a mandatory minimum penalty, a judge is supposed to sentence somebody to that minimum period of time, possibly a lot more. And that has changed the leverage that prosecutors have when it comes to charging decisions and plea negotiations.
Well, the reality of our system is that if a defendant goes to trial, the defendant and his lawyer know that if he gets convicted, he's going to get sentenced far more harshly than if he agrees to settle the case by plead guilty.
And there will be some people who will say, well, gosh, I'm innocent, but I'm aware of the fact that there is some evidence that makes me look pretty bad, and that a prosecutor might well get a conviction. If I accept this plea bargain, I might get a 3 or 4 month sentence. If I am convicted of this mandatory minimum offense, I will get a 5 or 10 year sentence. And so some people will say, well, even though I am innocent, I realize things look bad for me, therefore I will take that plea.
The idea that you're somehow coercing an innocent defendant to plead guilty to a crime that they did not commit because they fear the mandatory minimum ignores the reality that most of these criminal cases in federal court are incredibly strong. And it also, you have to accept that the grand jury indicted a case that was not supported by the evidence, that a criminal defense attorney who has reviewed the discovery believes that their client should plead to a crime that they did not commit. And it also overlooks that in the federal criminal justice system, no defendant can plead guilty to a crime unless a U.S. District Court judge makes a finding that that plea is supported by a factual basis. The judge must be convinced based upon the colloquy and the evidence in the record at the plea hearing that the defendant committed the crime that he's pleading guilty to committing.
Prosecutors, as I say, by controlling the charges, they control the sentencing. Because if you bring a charge that carries with it a mandatory minimum, the judge can't undermine that. You're effectively making the punishment by bringing the particular charge.
We're looking at the law, we're looking at the facts. Does it fit this offense, whether or not that offense carries a mandatory minimum? And if it does, and we think it's in the best interest to charge it, we'll charge it that way. And it's one tool, if you will, in the prosecutor's toolbox.
The job of a prosecutor is to enforce the law as written by Congress and signed by the president. The federal law at this point has mandatory minimums. The prosecutor's job is to follow the law and enforce the law. If people are upset about the existence of mandatory minimums, the proper forum is Congress, not the U.S. Attorney's Office, to raise that complaint.
We have a very important doctrine called prosecutorial immunity. Prosecutorial immunity means that a prosecutor is immune from being sued civilly for his conduct as a prosecutor. All the conduct that a prosecutor does in terms of charging, plea bargaining, trials, hiding evidence, even bribing a witness, a prosecutor enjoys absolute immunity from being sued civilly.
The overwhelming number of cases, prosecutors are immunized. Now, I've never understood this. I've always been on the defense side for 35 years. I screw up, I get sued. I got to defend myself. If I can't defend myself, I got to pay up.
Ask yourself, recognizing the fact that, like the rest of us, they're human, if you can win a case through misconduct by basically cheating in effect with the knowledge, or at least a fairly high degree of certainty, that there will be no repercussions for you personally if you do that, essentially that you will get away with it. Which way does that, what kind of incentives does that create?
The idea behind absolute prosecutorial immunity is that if the prosecutor had to fear that every one of those defendants would bring a civil lawsuit against the prosecutor for wrongful prosecution, that the prosecutor would, first of all, be deterred from making the tough decisions, and second of all, that the prosecutor would essentially have to create an entire wing of the prosecutor's office devoted to nothing but defending all of the civil lawsuits, because it is pretty much a given that a large percentage of the defendants that a prosecutor prosecutes would want to sue the prosecutor.
Those prosecutorial decisions have to be made independently without that sort of fear. Prisoners, criminal defendants in particular, are especially litigious.
Now, I recognize that that's a concern, but it is a concern that could absolutely be addressed and dealt with far short of completely eliminating civil liability for prosecutors, which is the only real means of truly effective accountability available to us.
The Supreme Court, I think, has said that the idea of prosecutorial immunity is really a balancing of evils. It's not like it's perfect in every instance, but overall, it's better for the system.
Prosecutors are hands down the least accountable people in America. They cannot be sued. They are virtually never prosecuted for their own misconduct. Internal disciplinary measures exist on paper, but they're a joke in practice. There's an extensive body of literature that shows that prosecutors routinely get away with jaw-droppingly unethical and improper behavior.
This notion that there is widespread prosecutorial misconduct is simply a myth. On any given year, there are about 2.2 million felony prosecutions. And in the same year, there are usually about 60 findings of prosecutorial misconduct. That's infinitesimal. And to suggest that with the robust checks and balances we have in place now, there need to be more to focus on a problem that is really non-existent, I think is misplaced.
I like to think that those instances are few and far between, but they certainly happen. And one should examine them very carefully to find out what went wrong and what can be done to make sure something like that doesn't happen again, or at least dramatically minimizes the likelihood that it'll happen again.
What's interesting is the courts, who presumably could oversee the prosecutor's discretion, exercise virtually no supervisory authority.
We have judges who have the authority to dismiss cases if the case is brought to trial and the government doesn't have sufficient evidence. They also have the authority to, if a prosecutor has engaged in some other type of misconduct, the judge can take action against the prosecutor.
The judge, who's part of the judicial branch, will make rulings based on the arguments of the parties. And so that keeps the prosecutor in check, if you will.
The criminal justice system is and ought to be ultimately the responsibility of judges. As neutral arbiters, it should be their job to ensure that everybody within the system is playing by the rules. That doesn't happen very often in our case, in our system, because prosecutors are really running the show from start to finish. Not much of the total amount of criminal litigation that goes on in America today happens in court. Most of it happens at the level of the prosecutor interacting with defendants and their attorneys.
Most of what a prosecutor does is in the public eye. It's on public pleadings, it's in briefs, and it's in open court. So the levels of review begin with the public, the media, the judiciary. Beyond that, of course, we have the Office of Professional Responsibility, and beyond that, every prosecutor is subject to disciplinary action by the Board of Professional Responsibility in their state. So all of those layers are there.
There are prosecutors who do violate the rules, sometimes often. And these prosecutors should be weeded out. They should be weeded out either by their own offices or by the system of professional discipline. And they do give prosecutors a bad name, just as bad police officers give police officers a bad name.
The stakes are high when it comes to criminal law. Again, respect for the rule of law in our society largely comes down to how does our criminal justice system operate? Do people get a fair shake, both victims and people who are under investigation?
People always tell me it may not be a perfect system, but it's the best system that we've devised. And I always tell them, conceptually, I agree with that. But if this is the best, then that's frightening. Because all you have to do is hang out in any courthouse for any period of time in virtually any jurisdiction, and you would be appalled by what you see on a daily basis.
We've created a situation where it's extremely difficult for criminal defendants to have a zealous representation, and we've equipped prosecutors with an astonishing array of coercive tools that they can and do bring to bear on people to extract confessions, and that's why most criminal convictions today, more than 95%, are obtained through plea bargain. It's not because people are no longer interested in exercising one of the most hallowed and hard-won rights in the Constitution, which is the right to a jury trial. It's because they're being pressured and coerced into pleading guilty, whether they're guilty or not, and that has got to stop.
The fact that we have so many people in prison is not as a result of overly zealous prosecutors or enforcement. It's a result of the fact that we have too much crime. And you can look to whatever causes you want for that crime, whether it's people don't have job opportunities, whether it's the educational system, whether it's a breakdown in the family structure, whatever it is. And our job as prosecutors is, at the end of the line, is to deal with that. And the way we have to deal with it is to incarcerate people who victimize the good and honest citizens who are out there in the community.
I do think that the vast majority of prosecutors take their duty to do justice and not just to seek convictions very, very seriously. And so they're out there every day investigating to see, has a crime even been committed? If a crime has been committed, what crime was it? And who's responsible, and trying to make the best decision possible about what charges to bring and who to charge.
I mean, I think the prosecutor's job is one of the great jobs anybody could hold. As I said, I couldn't wait to get to work. I felt I was privileged, honored to be a prosecutor, to be able to serve the public this way, to be able to serve justice. It's a wonderful, wonderful profession. But it needs those people who are inspired to do the right thing, to make sure that they're going to follow the rules, to ensure that at least the best of your ability, that society is being protected, but that individuals are not being unfairly, improperly, wrongfully accused and punished.
The idea that we're ever going to find a perfect answer to this neglects the fact that what we're talking about is a system created by human beings dealing with other human beings. And as we approach the debate, what's important, I think, to remember is that both sides are approaching it in good faith with ideas about the way in which they think improvements should be made or improvements are unnecessary. But at the end of the day, people who are on both sides of the debate are well-meaning, and we have to be careful that we don't somehow paint the people who don't want the reforms as a particular type of person and those who are seeking the reforms as a particular type of person. Instead, we should relish the debate. It's an important debate. It's one that we should be having.